Stop. Before you say a single word the next time a cop tells you, I smell alcohol on your breath, you need to hear this. Because right now, in courtrooms all across America, that four-word phrase, I smell alcohol, is being used as the launching pad to arrest people, suspend their licenses, and upend their entire lives. And here is the part that should make your blood boil. Science says the officer's nose is not evidence. Did you know that ethanol, the actual alcohol in your drink, is chemically odorless? What that officer is smelling isn't alcohol at all. It's the hops in your beer, the tannins in your wine, the fermentation byproducts in your cocktail. And here's the real bombshell. A completely sober person who never touched a drop of alcohol can produce that same smell because of a medical condition affecting 20% of the American adult population. I'm going to walk you through the exact science, the exact law, and the exact words you need to counter a subjective, unverifiable sensory claim with objective, documented fact. By the end of this video, you will understand why I smell alcohol is one of the weakest forms of evidence in DUI law, and how demanding objective proof protects your Fourth Amendment rights on the spot. Stay until the end because the section on what to say at the roadside has saved people from wrongful arrests. Let's get into it. Let's start with the science because this is where the officer's case begins to crack. Ethanol. That is the specific chemical compound, formula C2H5OH, that is the intoxicating substance in every alcoholic beverage. And here is the fact that most people, including many police officers, do not know. Pure ethanol has little to no detectable odor. This isn't a legal opinion. This is chemistry. What you actually smell when someone has been drinking are called congeners. These are the flavoring compounds, fermentation byproducts, and volatile organic compounds that give each alcoholic beverage its unique taste and aroma. We're talking about acetaldehyde, fusel oils, esters, hops, tannins, and grape compounds. The beverage smells, the alcohol itself does not. Now think about what that means in practice. Defense attorneys have proven this point in court for decades using one very simple demonstration: near beer. Near beer is a non-alcoholic malt beverage made with the same grain, malt, hops, and yeast as regular beer. It looks like beer, it smells exactly like beer, and if you handed it to a police officer after someone drank it, that officer would note a strong odor of an alcoholic beverage. But the driver's blood alcohol concentration? 0.0. And it gets worse for the prosecution's case. Here's another fact that DUI defense attorneys use to systematically challenge odor testimony in court. The strength of the smell has absolutely no correlation to blood alcohol concentration. None. A person who drinks a single craft beer with heavy hops will produce a far more intense odor than someone who consumed 3 or 4 vodka sodas with a significantly higher actual blood alcohol level. Beer and wine, the least intoxicating beverages per ounce, leave the strongest odor. Vodka and gin leave almost none. An officer who tells you they smelled a strong odor cannot tell you what you drink. They cannot tell you how many drinks you had. They cannot tell you when you had them. And they absolutely cannot tell you what your blood alcohol level is. In fact, in controlled research studies used by DUI defense attorneys, officers were tested to see if they could accurately assess a person's impairment solely on the smell of their breath. They were wrong almost every single time. So, let's be crystal clear. The smell of what an officer perceives as alcohol is qualitative, not quantitative. It's subjective, not scientific. And in the courts of multiple states, including Tennessee, Alaska, Ohio, Wyoming, Colorado, Wisconsin, Louisiana, and Washington, case law is consistent. The odor of alcohol alone does not constitute probable cause for a DUI arrest. Now that you understand why smell is scientifically unreliable, let me introduce you to the concept your attorney will use and that you can plant the seed for right there at the roadside. It's called the Nexus Demand. In legal terms, a nexus means a direct, documented link between two things. For a DUI arrest to be constitutionally valid under the Fourth Amendment, an officer needs probable cause, not a hunch, not a feeling, and not a sensory impression. They need an articulable, specific connection between observable facts and actual impairment. The smell of something is not impairment. Smelling like a brewery and being impaired are two completely different legal and biological realities. The Florida courts made this clear in State of Florida versus Clip House, ruling that probable cause for a DUI arrest must be based on more than a belief that a driver consumed alcohol. It must be based on facts and circumstances showing a probability that the driver is actually impaired. The smell of alcohol flavoring alone? That's not it. Here's how the nexus demand strategy works in practice. When an officer says, "I detect an odor of alcohol," the scientific rebuttal framework does three things. First, it challenges the qualitative observation. The officer smelled something, but what exactly did they smell? They cannot identify the beverage, they cannot quantify the smell, they cannot translate that smell into a blood alcohol number. Subjective olfactory observation, on its own, is legally insufficient. Second, it demands a shift to objective chemical evidence. There is exactly one way to know if a person's blood alcohol concentration is above the legal limit of 0.08%, and that is a chemical test, either a properly administered breath test or, ideally, a blood draw. An officer's nose is not a calibrated instrument. A gas chromatographer is, and those two things are not equivalent. And third, it redirects the probable cause narrative. If an officer has nothing beyond a smell, no slurred speech, no erratic driving, no bloodshot eyes, no failed coordination, then the foundation of any arrest becomes extremely shaky. You are documenting that reality from the very first moment of the stop. Now, here is where the science becomes genuinely powerful, and where a completely sober driver can neutralize an officer's smell-based suspicion entirely. Let's talk about GERD. Gastroesophageal reflux disease, or GERD, affects an estimated 20% of American adults. That is roughly 60 million people in this country who experience it at least once a month. What GERD does is cause the lower esophageal sphincter to malfunction, allowing stomach contents, including stomach gases, acids, and anything you've recently consumed, to flow back up through the esophagus and into the oral cavity. Why does this matter during a traffic stop? Because if you've had any alcohol at all, even one drink hours earlier, a GERD episode can push alcohol vapors directly into your mouth and throat. The officer isn't smelling impairment, they're smelling your stomach contents. And here is the critical physiological distinction that breathalyzer technology often fails to account for. A breathalyzer is designed to sample deep lung air, what's called alveolar air, which reflects your actual blood alcohol concentration. But it cannot distinguish between deep lung air and mouth alcohol, vapors sitting in your upper digestive tract from a GERD episode. If you have a GERD episode right before blowing into a breathalyzer, the reading will be artificially and dramatically inflated, reflecting nothing about your actual impairment level. Most states recognize this problem. California law, under Title 17 of the California Code of Regulations, actually requires officers to observe a DUI suspect for a continuous 15-minute period before administering a breath test, specifically to allow mouth alcohol to dissipate. If that observation period is skipped, and defense attorneys find this happens frequently, the breath test result can be challenged in court. Now, let's talk about the second biological factor, mouth alcohol itself. Beyond GERD, alcohol from a recent drink can linger in the mucous membranes lining your mouth and throat for a significant period of time. Dental work creates another layer of complexity. If you've had recent dental procedures or have cavities, alcohol can literally pool in those spaces and remain detectable long after the alcohol has been absorbed into your bloodstream and cleared. This phenomenon is documented in peer-reviewed forensic science literature and has been used successfully by defense attorneys across the country. Here is the legal implication. If you have GERD, acid reflux, recent dental work, or any other condition that creates mouth alcohol, you need to state that clearly and calmly at the roadside. Not aggressively, but specifically. Say it. Document it. Officer, I want to note for the record that I have a diagnosed GERD condition that can affect breath readings and produce a smell that mimics alcohol consumption. That single sentence creates a documented medical context that your attorney can use later. Beyond your biology, your environment can manufacture the exact same sensory experience the officer claims to be detecting. Let's run through the most common environmental contamination factors that DUI defense attorneys use to challenge odor-based probable cause. Hand sanitizer. After 2020, hand sanitizer became one of the most universally present products in vehicles across America. Most hand sanitizers are 60 to 70% ethyl alcohol or isopropyl alcohol by volume. Use a few pumps of hand sanitizer in a closed vehicle, and that cabin will smell like a distillery, not because you drank, because you sanitized your hands. Windshield washer fluid. Most commercial windshield washer fluids contain methanol or ethanol as their primary active ingredient. Running your washer system recirculates those fumes directly into the car's air intake. An officer approaching your window after you've been using your washers on a long drive is absolutely detecting that chemical residue, not beverage alcohol. Mouthwash. Listerine is approximately 26.9% alcohol by volume. Scope is around 19%. That is stronger than most wines and stronger than many beers. If you used mouthwash 15 minutes before being pulled over and an officer leans into your window, they are smelling your oral hygiene routine, not a DUI. Breath sprays and certain over-the-counter medications. NyQuil, certain cough syrups, and some breath sprays contain alcohol bases that linger in the oral cavity and trigger the same congener-based odor response that an officer associates with drinking. Here is your roadside script for environmental factors. If an officer mentions detecting an odor, you respond calmly and specifically. Officer, I do want to note that I've been using alcohol-based hand sanitizer in the car today, and I used mouthwash before I left the house. I'm also happy to cooperate with any objective chemical testing if that's required. That response does several things simultaneously. It provides a documented alternative explanation. It demonstrates calm, rational thinking, not the behavior of an impaired person. And it signals to the officer that you are aware of your rights and the science involved. All right, you've got the science, you've got the law. Now let's talk about what you actually do at the roadside, because this is where it all comes together. Step 1. Understand what you are legally required to provide. In every state, you are required to provide your driver's license, registration, and proof of insurance. That's it. Your Fifth Amendment right against self-incrimination means you are not required to answer questions about where you've been, what you've had to drink, or where you're going. Politely say, I'm happy to provide my documents. I prefer not to answer questions without speaking with an attorney first. That is your right. That is not obstruction. Step 2. The field sobriety test decision. In most states, you are not legally obligated to perform roadside field sobriety tests. The walk and turn, the one-leg stand, the horizontal gaze nystagmus test. These tests are not infallible. They are graded subjectively by the officer conducting them. Research has shown that even completely sober people fail them under the stress and conditions of a nighttime traffic stop. The National Highway Traffic Safety Administration itself acknowledges that standardized field sobriety tests are only accurate about 80 to 90% of the time, even when administered perfectly. And they are frequently not administered perfectly. Your script: Officer, I respectfully decline to perform field sobriety tests. I would prefer to speak with an attorney before participating in any testing. Step 3. The chemical test decision, and why blood beats breath. This is critical. In every state, you face legal consequences, typically automatic license suspension, for refusing a chemical test after a lawful arrest. This is called implied consent law. You agreed to this when you accepted your driver's license. Understanding implied consent is essential. However, if you are going to submit to chemical testing, requesting a blood test rather than a breathalyzer is often in your best interest. Here's why. A breathalyzer has all the vulnerabilities we've discussed: mouth alcohol, GERD interference, calibration errors, and congener cross-reactivity. Fusel oils, those fermentation byproducts we talked about, can actually be misidentified by infrared breathalyzer technology as ethanol, inflating your reading. The Michigan State Police Toxicology Lab has confirmed this in published literature. A blood test processed by gas chromatography at a certified lab is dramatically more accurate and more defensible. It also creates a preserved sample that your attorney can have independently retested. Your script: I understand my implied consent obligations. If I'm required to submit to chemical testing, I am requesting a blood test, not a breath test. Step 4. Document everything immediately after the stop. Before you do anything else, write down every detail you can remember: the exact words the officer used, the lighting conditions, whether the 15-minute observation period was followed before any breath test, whether you had GERD symptoms, what products were in your car, whether you used hand sanitizer or mouthwash. Every environmental and biological factor we've discussed becomes a brick in your defense wall, but only if it is documented. Modern DUI defense is built on challenging subjective police observations with objective, documented, scientific alternatives. Every single piece of information you preserve is a tool your attorney can use. Courts across America are increasingly skeptical of DUI cases built primarily around subjective sensory observations. Multiple state appellate courts have affirmed that odor alone is not probable cause. The science is clear. The law is developing in favor of requiring objective evidence of actual impairment. But none of that protects you automatically. You protect yourself by knowing the science, stating the right facts at the right time, exercising your rights calmly and specifically, and getting an experienced DUI defense attorney the moment you can. The officer's nose is not a scientific instrument. The law knows it, science proves it, and now, so do you. If this gave you information you didn't have before, do one thing right now. Hit that like button. It tells YouTube that this content is worth putting in front of more people who might need it. Drop your questions or your own experiences in the comments below. Have you or someone you know been in a situation where the officer's smell claim was the starting point? Let's talk about it down there. And if you want to go deeper on Fourth Amendment traffic stop rights, breathalyzer science, or field sobriety test challenges, subscribe because that content is coming. This is Legal Logic. I'll see you in the next one.